This is Barry Zalma on insurance. I am an attorney who is retired from the practice of law and now spend my time, among other things, making these videos. Today, I'd like to talk about how to become a professional liability claims adjuster. The investigation of a liability insurance claim is conducted to allow an insurer to fulfill the promise made by the insurer to defend and indemnify the insured in the event of a contingent or unexpected loss resulting in the injury to person or property as a result of actions of the insured. To fulfill the promises made by the policy, insurers must establish a professional group of insurance adjusters who are competent investigators and competent insurance claims people. The adjusters, at a bare minimum, with regard to third-party liability claims, must be capable of fulfilling, at a minimum, each of the topics that follow. The claims person must be ready and able to read and understand the policy. So to understand a third-party liability policy of insurance, the adjuster must read and analyze the policy in a logical and thorough manner. When reading a liability policy of insurance, the adjuster must understand that the facts of each individual claim clarify and color the interpretation of the policy contract and bring different nuances to the policy wording. The adjuster must know what coverage is available to the insured, the limits of liability, the territorial limitations, and the exclusions, conditions, and endorsements attached to the basic form contracts of insurance. The adjuster must, second, establish the existence of coverage. Before even beginning to investigate a claim, the adjuster must first establish or confirm coverage. To do this, he or she must get a complete copy of the insurance policy. The company's copy, called the daily and paper-based insurers, is available from the underwriting department. For those insurers who now record everything electronically, which is almost every insurer today, the full policy is available in the insurer's intranet. Whether paper or digital, the adjuster must determine that the person reporting the claim is an insured of the insurer. In my basic history as a young adjuster more than 53 years ago, I worked for the Fireman's Fund Insurance Company, and occasionally we would receive reports of claims that really belonged to Fireman's Insurance Company of Newark. That would cause confusion, and sometimes they'd be paid by the wrong company, and eventually the problems would be worked out. The policy also must be established as being in effect when the injury occurred. The adjuster must establish that the policy was in effect when the claim was made, if the policy is a claims made or a claims made and reported policy. The adjuster must find the declaration page and review it to determine the basic coverages available, the dates the policy in effect, and the limits of liability of the policy. The adjuster must determine which standard forms of liability insurance coverage exist for the particular insured and make certain that he or she has read and understood those forms. If only a paper copy of the declarations page is available, the full policy can be recreated from the standard forms listed on the declarations page available from the underwriting department or the insurer's intranet. If none are available, the adjuster can always obtain a copy maintained by the insurance agent or the insured. The adjuster must also determine the policy limitations, the perils insured against, and determine if the policy is a homeowner's policy, a comprehensive general liability policy, an auto liability policy, a commercial general liability policy, an errors and omissions policy, a business owner's policy, or some other variety of liability insurance policy. Each policy will have an insuring agreement where the risks accepted by the insurer are listed. The adjuster next reviews whether there exist added endorsements that increase, decrease, or modify the coverages provided by the standard policy wording. The adjuster must be familiar with each of the liability policy wordings, including the exclusions or exceptions from coverage. The so-called concurrent cause doctrine can modify how liability is determined when there are multiple causes that join to injure the claimant. In such a situation, the concurrent cause doctrine holds that if more than one cause concurs with others to bring about a loss, and one cause is excluded and the other is not excluded, coverage will apply regardless of the proportion with which the non-excluded cause was related to the loss. The thorough investigation conducted by all liability claims adjusters must determine all causes that join to injure the claimant or the claimant's property. Each cause must be evaluated in light of the facts developed during the investigation to determine if one of the causes is covered by the policy wording and not excluded. If multiple potential causes are discovered, analysis is required if some causes are excluded to determine which cause of loss is the predominant or moving cause of loss. The adjuster must establish that the person making a claim is named as an insured or is an insured as a result of the wording of the policy. Third, the adjuster must read and understand the loss notice. The loss notice is one of the most important documents the adjuster will see. It is the starting point of all claims because it tells the adjuster the name of the insured's address, telephone number, and email address, the name, address, and telephone number of the claimant, the date the accident occurred, the location of the accident, the basic facts of the accident, and the identity of any witnesses. Fourth, the adjuster must meet with the insured and witnesses. Once the adjuster has completed the basic preparation by confirming coverage, the adjuster should explain to the insured that the policy requires the insured to cooperate and assist the insurer in completing a thorough investigation of the claim being made against the insured. The explanation should include that the insurer, in order to provide the best service possible, it is the adjuster who helps the insured and who acts in good faith on behalf of the insurer to its insureds. The insurer hired the adjuster to help the insured protect himself or herself from claims by the third party claiming injuries as a result of the negligence of the insured. The adjuster must also explain that he or she cannot provide the defense alone. The adjuster needs the assistance of the insured and is present to help the insured obtain the defense needed. To act in good faith, the adjuster must not do or fail to do anything that will deprive the insured of the benefits of the policy of insurance. And to begin the investigation, the adjuster should at least begin with a recorded statement of the insured. The adjuster must take a complete recorded statement from the insured and all witnesses to the incident that caused the loss. The recorded statement must get answers to the most important of all questions relating to the claim presented against the insured. Who was involved? What happened? Where did it happen? Why did it happen? When did it happen? And how did it happen? Each of the famous 6 questions must be answered with regard to both the policy and the loss. Recorded statements of neighbors, relatives of the insured, independent witnesses, and people who may have seen the loss-causing incident may also be useful in obtaining a complete picture of the loss. The adjuster should also work to develop witnesses not known to the insured. Witnesses can be discovered by visiting the scene of the accident, talking to businesses local to the accident scene, seeking security videos and independent people who may have observed the incident. Reports from governmental authorities such as police departments and fire departments, ambulance drivers, and other official entities might be useful. The Fair Claims Practices Regulations enacted in many states, following a National Association of Insurance Commissioners model, set of authorities regulations require prompt and thorough investigation of every claim reported. The adjuster should also obtain relevant documents such as leases, documents establishing title to real property and personal property such as automobiles, contracts between the insured and others relating to the incident, other insurance available to the insured, certificates of insurance adding the insured as an additional insured, each and every indemnity agreement in favor of the insured, driver's licenses and passports. If an auto loss, the reports made by the insured to the Department of Motor Vehicles, or if the auto has a black box, the records maintained by the box. If an auto loss and a video recorder exist in the auto, a copy of the recording and any other document that might be relevant or material to the investigation. The adjuster must establish the amount of loss and claim, and for property damage claims, determine a scope of loss. In addition to obtaining the scope of loss in a bodily injury claim, the adjuster must determine the extent of the injuries and treatment and read all of the medical reports, and if necessary, obtain the assistance of an expert in the medical professions. The adjuster should also photograph the scene of the accident and contact all professional and public authorities. And eventually, the adjuster must determine the value of the loss. Finally, the adjuster must confirm that the conditions, warranties, and terms of the policy have been performed adequately by the insured. Since liability policies are issued based upon the truth of matters stated in an application for insurance, the adjuster's interview with the insured at the inception of the investigation should ask, without looking at the application itself, every question of substance asked on the application, as if the questions were customarily asked of every insured who reports a claim, which of course it should be. The adjuster is obligated to include within the investigation whether the policy was obtained by an insured honestly treating the insurer with the utmost good faith. If coverage issues arise as a result of the investigation, the adjuster should seek permission to retain an experienced coverage lawyer to advise how to resolve the coverage issues. In addition, with serious injuries, it is preferable to also retain consulting physicians who can review the medical records and, if the injuries seem inflated, conduct an independent medical examination of the claimant. The adjuster is an investigator, an insurance contract expert, and a person of empathy who fulfills the promises made in the policy to defend and indemnify the insured. In doing so, the adjuster also protects the assets of the insurer so that only the claims owed are paid. The adjustment of a liability claim commences with the loss notice and ends with a settlement or refusal to pay. This video was adapted from my book, The Compact Book of Adjusting Liability Insurance Claims, 2nd edition, which is available as both a Kindle book and as a paperback from Amazon.com. If you found this video to be useful, please refer it to your colleagues, and please subscribe to my YouTube channel and to my blog so that you can be advised of future reports, blog posts, and videos. Thank you for